Well, so much there about digital innovation and creative excellence. We take a short break now. And when we return, we'll be talking to Liborous Oshoma, a lawyer and human rights activist. Stay with us. We'll be right back.
The Fidelity Gets Alerts in Millions promo is back and better. This time around, we're giving out a whopping 159 million naira. 10 customers stand a chance to win 1 million naira in the monthly draw. That's not all. You can also win 2 million naira, 5 million naira, and 10 million in the grand draw. To qualify, open any Fidelity savings account with 5K or fund your existing Fidelity account with multiples of 5K to get more tickets in the draw. Then sign up to either our mobile app *770# or get any of our Fidelity debit cards. Remember, the more 5K you save and transact, the more tickets you get into the draw. This promo is open to new and existing customers and runs from now till August 20, 2025. This promo is approved by National Lottery Commission and the FCCPC.
We are Fidelity. We keep our word. In November 2024, the Supreme Court of Nigeria, our highest court, delivered a landmark judgment on lottery and gaming regulations. The judgment nullified the National Lottery Act of 2005, thereby upholding the constitutional right of the states. Yet today, some lawmakers push the Central Gaming Bill 2025, a blatant attempt to defy our Supreme Court and weaken our constitution. No lacuna, no shortcut. Online gaming does not strip the states' right. This is the rule of law, the supremacy of our constitution. If they defy the Supreme Court today, what will stop them tomorrow? This is not just legislation, it is an assault on justice. The Supreme Court cannot and must not be silenced. Tell your lawmakers, stop the Central Gaming Bill 2025. Protect our judicial institutions. Justice must stand and the Constitution must prevail. Sponsored by Federation of 26 States Gaming Regulators.
Welcome back to the morning show here on Arise News. The affirmation of Monday Okpewolo as the duly elected governor of Edo State by the State Election Petition Tribunal sitting in Abuja, the Federal Capital Territory, has been welcomed by mixed feelings as some politicians have expressed divergent opinions on the judgment. It will be recalled that the three-man panel headed by Justice Wilfred Pochi on Wednesday in his judgment validated the electoral victory of Governor Monday Okpewolo, a candidate of the All Progressives Congress, APC, in the September 21, 2024 governorship election in the state. Asoe Godalo, a candidate of the People's Party, Democratic Party, PDP, and 15 other candidates were defeated by Governor Monday Okpewolo.
This is not a news to us because Edo people have spoken before. The court has just reaffirmed what Edo people voted for. So we want to thank God, we want to thank the people of Edo. And I also want to congratulate my principal, the executive governor of Edo State, distinguished Senator Monday Okpewolo.
It's victory for the great people of Edo State because it's not a victory for Monday Okpewolo, it's victory for Edo State because Monday Okpewolo is the governor of Edo State. He was elected by Edo people. And we are using this opportunity to call on everybody in the state to come together at this point so that we can move the state forward.
Now, with respect to the judgments delivered had absolutely nothing, no semblance whatsoever with all the documents that were circulating yesterday. So it is really kudos to the judiciary, number one, and then especially congratulations to the learned judges of the tribunal. There are 3 stages of the process. This is only the first stage, but we are quite happy on behalf of our clients, the governor, that at least we have emerged victorious at this stage.
The tribunal dismissed our case. That's the summary of everything. But we are very hopeful that some issues that we raised and we canvassed, we'll frame them up and we'll appeal. We'll see how we can advise our client on something.
Joining us now on this show to review and analyze the ruling by the Edo Election Petition Tribunal is Liborous Oshoma, a lawyer and a human rights activist who hails from Edo State. Thank you for joining us.
Thank you. Good morning.
Okay, you are from Edo State, so
yes.
I don't need to tell you the story of your state. What's your take on this latest development?
Yeah, the first thing is, in one breath, we say we don't want courts to interfere in our electoral process. But in another breath, we wait for courts to interfere, and we're waiting for court to make a pronouncement on the same electoral process. And so, over time, you see that since governorship election petition terminates at the Supreme Court has streamlined the process for determining election petition. If you look at Section 135 and Section 134, Section 135 states that election cannot be invalidated on certain ground. And Section 137, mainly after the amendment of the Electoral Act 2022, Section 137 was introduced. And it was also to help the limitation created with the 6 months time limit. But if you remember, we're in this studio here, the Oyetola and INEC case in Oshun, that PDP won. The ground for the challenge of APC then was almost the same thing like what PDP is challenging in Edo State. And their ground was a substantial non-compliance and overvoting and irregularities, hinging their argument on Section 137. And the Supreme Court ruled in that matter that the fact that Section 137 states that you can do without oral evidence does not mean that you can discountenance oral evidence when the documentary evidence of the tribunal, but when the documentary evidence are not manifestly showing irregularity, so you still need oral evidence. And so an oral evidence is you have to call witnesses pulling units by pulling unit to prove irregularity. And so when you look at the 6 months window, you now ask yourself truly, how much can the petitioner do within 6 months? So when I look at all of this, I just tell myself, look, I think we should rather focus on INEC so that election would be determined at the poll instead of waiting for a tribunal to do something.
Okay, while we focus on INEC, BVAS is a big part of this conversation because still sticking with that Section 137, it's about the extrapolation of the data from BVAS. Yeah. Now, there seems to be a bit of confusion. Is it that we hand over the BVAS machine and that's our evidence? Are we to extrapolate it? Can you explain to us if there's a gray area where the law is concerned or if we are missing the interpretation? Because it seems everybody has their own interpretation of what they do with the BVAS and the data inside it.
Yeah, this same argument came up in the Oshu Tribunal matter. You remember Matthias, Meribey, and I were on this same, studio. And before then, my argument was that once the information from the BVAS are extracted, and that it was enough. But the Supreme Court, in its wisdom, heard otherwise and said no. That and that was Matthias' position then also, that the BVAS, once there's a conflict as to the documentary evidence presented, and then you have to resort to the primary source of evidence, which is the BVAS now. You have to examine the BVAS. And if you remember, the last time a court nullifies election in Nigeria on grounds of irregularity was when, before the 60 days window, when we had, 3 years and 2 years, 1 year plus to determine election petition. In the case of Peter Obi, they called almost 300 witnesses to be able to prove irregularity. In Oshomole's case also, and for Peter Obi, it took them almost 3 years. For Oshomole's case, it took them 1 year plus. In the case of Oshun Aregbesola, they had to bring in a forensic expert, Adrian Forty, to do data analysis and fingerprint analysis on all the ballot papers, and that also took them a long time. So with the Supreme Court position now, you will need to examine the physical BVAS machine. And then, like we say consistently, and I'm trying to remember this learner Sikh, he appears on this program regularly. He has mentioned it consistently that the presumption of correctness is in favor of INEC. Yeah, and that because, yes, per clerk. And that once, because of the presumption of correctness in favor of INEC, the onus now shifts on the petitioner to prove irregularity. So, and that onus is very tall. You know, so once results are announced, the law presumes that everything is done correctly. And in some cases, just like the case of in Oshoma, the documents presented by INEC to APC were in conflict with the documents eventually presented by INEC in court. And the APC held tenaciously to those documents that once those documents were received by INEC, and that was all that they spoke, you know, to the outcome of the election. But eventually, the court ruled that because INEC, as at the time INEC presented those documents to them, INEC had not reconciled documents from their back end. And so after reconciliation, certainly there will be variation. So, and also hinging the judgment on the presumption of correctness in favor of INEC. And so except we further amend section 137, there's no way you're going to see, you know, a tribunal upturn judgment
so
at the...
A couple of points I want to ask. In the Imo case, it was a police officer that was not even present that was called as a witness and that ratified a level of irregularity. Correct me if I'm wrong, please. Yeah. In this Edo case, they said, oh, eyewitness is based on hearsay.
Yes, yes.
But in Imo, that same police officer, they accepted. Can you please explain that part?
I was at the tribunal in Imo.
And secondly, this one now that they say you have to walk the BVAS machine, does it not even complicate the case? Because if you are suing INEC and the party that won, and INEC is the custodian of the BVAS machine, is it not a joke we are pulling? Because see, in other climes of the world, in America, for instance, the company that gives them the electoral machine are independent party company, third-party companies. And that's why when the likes of them, Tucker Carlson, was saying voter fraud in America, it was that independent company, not the American Electoral College. It was that independent company that took Dominion, if my memory serves me right, that took Fox News to court and indicted Fox News. So they said they wanted to settle before the case came up in court, and they paid over $700 million for spreading fake news against that independent company. Shouldn't we have the same in Nigeria for the sake of integrity? Because in an election where INEC is the one coordinating the BVAS, and you now say I should bring that BVAS to work, and I'm in court against INEC.
Rufai, let me take from the last question, the last analysis. You remember when APC were in opposition, this position was their argument that the presumption of correctness in favor of INEC is too bogus, and that there's need to shift that burden of regularity and then allow INEC, once there's elections are questioned, that INEC, the onus now rests on INEC to prove that they walked the talk. But Electoral Act has been amended and the presumption is still there. And then on the case of Imo, I was at that tribunal because I was shuttling between, I had matters at the Election Petition Tribunal in Abia, in Akwa Ibom, and Imo. And so, in that case, after every election, copies of results are handed over to the police who participated in the election. And so the judgment of the tribunal was that the policeman who participated in the election and results that were handed to them, the policeman was a competent witness to tender those documents. But in this case, if you were a collation officer, as a collation officer, and you had discrepancies, you are alleging discrepancies that happened at the polling unit, it is the competent witness to testify to what happened at the polling unit is your polling unit agent and not your collation officer. And what usually happens when we do cases for INEC, and if all your witnesses are polling unit agents, I don't even bother to cross-examine. Because the only question I will ask you, on the day of this election, this alleged irregularity, were you at that polling unit? You say no, but my polling unit agents were reporting to us. It becomes hearsay.
You see, that's why, you see, this burden of correctness. You see, that's why going to court definitely is a sham, as far as I'm concerned. Because how can you say, I am in court, it's PDP versus APC and INEC. You want those that will testify to be polling agents that INEC put in place.
No, not polling agents of the political parties.
Polling, what's it called? Is those that oversaw the election then?
No, you know, every political party have their polling agents at the poll.
Yeah.
So if a political party is questioning the outcome of a result, it is the polling agent of that political party who saw what happened at the poll that is the competent witness to testify for the party, and not the collation officer. For example,
not the collation officer.
Not the collation officer. It is the polling, because it is hearsay. It is direct evidence.
No, but isn't it their polling agent that they said is hearsay?
No, when you bring a collation agent, there are collation agents. There are agents at the collation center, and then there are agents also at the polling unit. And most times what happens, because some of these agents are not your party members, you just hire them. Some of them might even as abscond on the day of election.
Some of them can work for 2-3 political parties.
You know, so on the day of election, it may be after the election, some of them are nowhere to be found. And so you now begin to fish for people. And in most cases, sorry, Doc. In most cases, the people you find are your collation agents who were members of your party. So when you present those agents, the question we usually ask is, were you present? And he says, no, I just got information from, I was a supervisor and I got information. So that means you were not directly involved in this allegation that you're complaining about. So it becomes hearsay.
Okay, Liborous. That's very simple. Let's go back to section 137 of the Electoral Act 2022, which says, you know, to alleviate the burden on petitioners, you don't have to adduce oral evidence. But in Oyetola versus INEC, it was decided that would be at the discretion of the judge, which was a decision that was upheld by the Supreme Court. Now, in the Edo case, the Tribunal case, are you arguing that that Tribunal, you know, its decision with regard to oral evidence is in line with the position of the higher courts? Because that's the argument of Monday Ubani, SAN, in an informed opinion that he wrote on this subject, I think yesterday. And he is saying two things can possibly happen. Either we amend section 137 of the Electoral Act, or the Supreme Court reverses itself on its earlier position if the matter goes all the way to the Supreme Court. That's number one. The other issue is that the Tribunal said that the witnesses were incompetent. And that's the whole thing you were saying about hearsay evidence, you know, maybe about 5 out of 19 qualified. The third point that Tribunal made was that documents were dumped on them, but that documents do not speak for themselves. And that, look, if the petitioner does not speak to the documents, the Tribunal could not have done that for it. And to that extent, they did not discharge the burden, you know, on their part.
Placed on them.
So can you just quickly address 137 and those other two positions that Tribunal
and that's
took?
why I started with section 137. And that the Tribunal couldn't have gone against the judgment of the Supreme Court. We are precedent in law. There's no way the Tribunal would have gone against...
So the Tribunal took the right decision?
Yes, the Tribunal took the right decision. And also, that's why I said, in Oshoma, when APC lost, they complained. And PDP said it was victory for democracy on this same issue. But today, in Edo, the same set of facts, the same ruling, and the tables have turned. APC now is the one rejoicing, PDP is the one complaining. That's why I started by saying, it's either we want the court to interfere or we don't want the court to interfere. And then secondly, on the competence of when a court says a witness is incompetent, that means you do not have direct evidence to what transpired. A hearsay witness is an incompetent witness, so why even bring him to court? And also, Thirdly, on the issue of dumping, that had been a recurring, decimal and judgment of the Supreme Court, starting from Bauchi, Kogi, even in Kano. And the court had, that's why at the initial stage, with the amendment of the Electoral Act, Section 137 was introduced to avoid the area of dumping. But the court also, the Supreme Court, in determining that question of dumping, was with this document that you dump on the tribunal, there is need for, even if the documents are direct, there's need also to speak to those documents and point to either the directness, correctness, or controversy in those documents. When I handled one of the matters, the central matters I handled at Abia, and the petitioner called about 18 witnesses, and all of them, all they just did was identify their polling unit results. And the tribunal said no, that apart from identifying your polling unit result, there's need also for you to speak to the controversy, if any, that is inherent or manifest in those results. So, but failure to so do, you don't expect, the court is not a Father Christmas, you don't expect the tribunal to go into chambers. And these were words specific of the tribunal in Kano. You don't expect us to go into chambers and begin to comb through the gamut of the documents, or go on a voyage of discovery for you and comb through the documents. And so, in the Edo Tribunal, when the PDP called, I think was it about 19 witnesses or so, or 16 witnesses, and 11 were said to be, or less than that, were said to be polling unit agent, and INEC refused to call witnesses. I told a friend of mine who was a supporter of the PDP, I said, look, your case, from what I'm seeing now, it means that you have not proven anything and to warrant INEC calling a witness to discredit. He said, why? I said, because I've represented INEC and I have, in similar circumstances, I've failed also to call witnesses. So, but I'm telling you this in confidence so that you understand the procedures. So when you have not been able to disprove that burden placed on you, INEC will not call witnesses. They'll just rest their case. It's like a no-case submission. They'll raise their case on your case and say, look, I don't need to even come and answer to these allegations because the burden of correctness. And then, going back to the Section 137 I talked about, is either, I agree with Mondo Bani SAN, it's either we amend Section 137 further, and I doubt if the Supreme Court will overrule itself. And so that's also the difference between,
but the Supreme Court can reverse itself.
Yes, but because the Supreme Court, yes, it can, but because the Supreme Court had been consistent in all of this, not just one judgment, they've been consistent on this issue, that you can't take away the discretion of the judge as to calling witnesses. You don't just, because when you do that, when the Supreme Court overruled itself, what is going to happen is that documents will be dumped on the court, and then you now expect the court to go back and say, I plead Section 137 that the document speaks for themselves, and so go into chambers and begin to look at the documents and sort them out for yourself. That will place a very big burden on the tribunal that it might take them more than 6 months to begin to deliver judgments.
Okay. Let's talk about concerns around legitimacy and interference in this process. We saw a flurry of documents that were released into the public space, purported to be the judgment prior to its delivery, and various documents, and they were all conflicting. My question to you is, and this is not the first time we're seeing something of this nature, where are we going wrong with that? Because it does bring into question the legitimacy of what eventually comes out.
Yeah. In the era of social media, we have to be also very careful. But before then, I would also, I think I just remember now the question Rufai asked on the BVAS machine, the usage of the BVAS machine. I think also, I have also been an advocate of BVAS machine being handled by an independent, body altogether. But the question we have, the big problem we have here, is not even the company that is going to handle the BVAS machine, who empowers or who employs that company, who employs the company. We saw cases where INEC would firm out, handling of logistics to National Union of Road Transport Workers. But it's an independent body. but who is handling that company? And so also a situation where INEC consistently, the chairman and in some cases resident electoral commissioners are appointed by the government, and the process of appointment, some persons, we've seen cases where national commissioners are appointed and the allegations that they are members of political party. So that also talks to the credibility of the process. Then secondly, on the issue of, when those documents came out, a colleague of mine, a very senior lawyer, also sent them to me and said, please verify this, authenticate. I asked him, I said, as a senior lawyer, how can you be asking me, is this how a judgment of a tribunal should be? He said, but in Nigeria, anything can happen. I said, but I doubt. But I think what the people that released those documents, what they attempted to do was they looked at the issue, the case in Oshoma. They knew that at the tribunal in Oshoma, it was 2-1. And so they just presume that just like Oshoma, and since the case is almost similar, the case of Edo is almost similar, so for Edo is likely going to be the same. And so that was why those documents were released and very scanty. And some persons even allege that maybe it might be the typists that typed those judgments that would. I said, no, this can't be a judgment. But because it's at the era of social media, anybody can sit down in their house and, concoct documents and just push them to the public domain. Because also, largely, because we do not have strong faith in our electoral process. And that's why what we need to do is look at the electoral process and determine where do we tweak it a little bit. Should we deploy technology fully? And then what is the hope and the faith that we have in those technology and who's handling those technology, for and on behalf of INEC? Once that happens, but like typical of politicians, no matter what you do in Nigeria, to some extent, there's still going to be mischief. But if the people have faith in the process, no matter how strong the mischief is, then you're certainly, the people can dismiss it.
So, if the judiciary is putting this burden of proof too high, then how do they want people to believe in them as the last hope for the common man? And I'll say this why. Because, see, you're saying when you are cross-examining the witnesses, apart from showing him the result, he must be able to speak to the events surrounding that result.
Yes.
Recollections might differ. Have we accounted for that? Secondly, when INEC sold this idea of a IREV or BVAS to us, what they told us, you can correct me if I'm wrong, was that after whatever happens in the polling unit goes on, all the agents of the party attest to the results. A picture is taken, it is loaded up on the server, the IREV. And that was to cure the 2019 malaise of no server. And we can all go to the server to be able to see it on that IREV. The BVAS for accreditation, unanimous acceptance of the result across all the party agents, and you load it on the IREV. Today, the Coalition Center of Transparency for Nigerians should be the IREV. But we do not have anything backing the IREV today. The IREV is not as copious as you even want it to be in the first place.
You see, Rufai, we should also be very careful because those machines, we don't operate them in vacuum. If you remember in 2015, when the card readers were introduced, the argument was that the card readers should replace the voters register. And the Supreme Court says since the card reader was not even known to our law, and so there is no way you can use the card readers to replace the voters register. And so in discussing or reckoning with overvoting, you must also be able to place the number of actual voters side by side, juxtapose it with the number of registered voters. And so subsequently, the law was amended to recognize card reader. And now when you talk about overvoting, it is the number of accredited voters using the BVAS machine as against the number of actual voters. And now, the Supreme Court had heard that the BVAS machine, the IREV is a viewing portal and not a collation portal. Because the rule states that there are 3 methods of collation. First and foremost, the hard copies of result sheet at the polling units from AC88. And then, if those copies are not available, the copies handed over to the from AC88 uploaded on the IREV. And if those documents are in the absence of those documents, the ones handed over to your polling unit agent can be tendered. In the absence of that, the one handed over to the police officers at the polling unit also can be tendered. So you have 3 hierarchy of collation. And so also, the question here now is that if you feel that there are discrepancies in the results that you have and what was uploaded in the IREV, the best evidence is to tender this result sheet. The competent witness is the man who handed those result sheets at the polling unit, and then you juxtapose them with the man who is collating. Failure to first and foremost bring the man who handled the result at the polling unit is fatal to your case. That's what the court is saying.
Please, we need to round up now, so I need the answers to be very precise. Now, there was another matter before the Tribunal, which was the matter brought by the Action Alliance and Adekunle Omaje. And the Tribunal made the point that, 1, Adekunle Omaje lacked locus. He was not a participant in the election. He was not recognized as national chairman. And that Action Alliance that he said was not allowed to participate in the September 21, 2024 election also did not, have, the nomination form signed by a valid and known chairman. Can you comment on that? Again, whether the Tribunal was on point.
Section 133.
In terms of law.
Because of time, I won't be able to read, because as you say, I should just go straight to the point. Section 133, if you look at Section 133 of the Electoral Act, it states clearly who can bring a petition. The fact that you're a political party does not entitle you to bring a petition. You must have participated in the election. The fact that you didn't participate in the election, you become a rabble-rouser. The problem here is that because the Tribunal are enjoined to take all applications and wait, deliver judgment at the final stage to avoid preliminary appeals. And so the Tribunal will have to entertain that frivolous petition, no matter how frivolous it is. But I think, going further, for petitions such as that, both the parties and the lawyers should be fine, so as to avoid a situation where you just feel a pre-election matter, you feel, you can bring it before the Tribunal, or maybe somebody can even pay you to just bring that petition, to use it to unsettle the other parties. Because it takes away the time that the Tribunal would have been using to deal with that. They would have concentrated and focused on the main issue, which is, the petition of the PDP. But when you have such petitions and then the Tribunal will have to look at it, no matter how frivolous it is, I think that there should be punitive measures for both the petitioner and their counsel.
So are you saying that these lawyers who bring frivolous and vexatious petitions to waste the time of the court, to forum shop, to just go around shopping for justice, they are part of the problem.
Yes.
And they should be sanctioned. Do you know some of them that you would like to mention?
Even if I know, I won't mention anyone here. You find that if not just the Tribunal, I try as much as I can, because I'm alternative dispute resolution savvy, I try as much as I can to take every step to resolve dispute before approaching the court. But you find lawyers, also this craze for senior advocates. People just approach the court with all kinds of frivolous matters, and court having to deal with frivolous cases. Not just the Tribunal. There are some cases that lack merit. Some you will see lawyers who file multiple cases. And that's why I think NBA also should step into such matters and begin to find a way to sanction such lawyers. In other societies, lawyers will be heavily sanctioned by the Bar Association for filing frivolous cases.
What do you do to judges that give funny judgments too?
Then you have the NJC. You bring petitions before the NJC.
So it's both ways.
Anyway,
Funny judges, funny lawyers.
These lawyers, they will be paid anyway.
Yeah, exactly, they will be paid, and nobody questioned.
Whether the advice is wrong or not. Thank you very much, Liborous.
My pleasure.
Always a delight to have you on the morning show.